Hey, good morning, guys. Good Friday morning. Get this set up correctly here. Sean Bougie here. You can check out our programs, of course, at SurplusFundsRiches.com. Surplus, F as in Frank, U-N-D as in dog, S as in Sam, riches.com. And get involved with us. I'm going to cover a couple of really key, important items today. One is I get a lot of people asking, how much money do I need to set aside if I'm going to get involved in this business? Well, if you're going to be a researcher for us, not a whole lot, guys. A lot of the lists are free online. Sometimes they'll charge you for copies, and that's about it, if you have to send off for it. And in that case, it's usually fairly reasonable, $5 to $15 to get a list. You send a self-addressed envelope with the check. You get the list, you research the debt and the ownership of that property, the debt against the property and the ownership of that property at the time of the sale. Because, again, if there was additional debt against the property at the time of the sale, that's entitled to the surplus, not the ex-owner. Also, you need to double check who the ex-owner was, because that list, particularly in tax sales, may have the owner as they showed it actually on their rolls years before, and they never updated it prior to conducting that auction. And a lot of people don't believe me with that, but that's true. They're not foreclosing, guys, a tax entity. They're not doing a tax deed sale on that property. They're not doing that against the owner. They're doing it against the property. They don't care who owns it. They have to give notification at the address and whatever else address they happen to have on file. They may not update their records prior to doing it, so you got to double check the ownership. Having said, that's all done online for free, guys, in most states. So with us as a researcher, that's it. You know, if you can't find an online list or they won't email one to you, then you can simply buy the list from a list provider if you'd like, or you can contact the county direct. And, if they charge you copies, you send a self-addressed stamp envelope along with the check, and you're good to go. Sometimes it has to be certified or a money order. But that's it. Now, if you're doing it on your own, that's a different animal. And this is why people work with me, and this is why I'd say well over, and I've quoted different percentages because it changes from time to time, but it's got to be over 20% of the people that end up working with me started with somebody else and then realized, it's not what I was told on the initial webinar or whatever marketing material I got. And Sean's telling us the truth about what we have to do and costs involved. If you're doing it on your own, we use a structured buyout. What that means is if somebody's owed 50 grand within a week after, and they do a deal with me and agree to, let's say, 25 grand, because my attorney's going to run me. I always hire attorneys. My attorney's going to run me, in that case, around 5 grand. I pay 10%, up to 10%, sometimes 13%, guys, with court costs and that type of thing. But anyway, I'm going to pay a certain amount to the attorney. I'm going to, of course, pay for a mobile notary to send this out. This is not if you're a researcher. This is if you're doing it on your own. I'm going to send a mobile notary out and also pay for the overnight for that to come back to me from the mobile notary. I'm going to hire the attorney and go forward. So on a 50 grand deal, I'd probably give 25,000 because I'm paying my attorney 5, I'm paying my researcher 4, I'm paying mobile notary and other expenses. Let's call it $1,000. It's probably more than that. But so I got 10 grand into it. That's 40. I'm giving them 25 or 40, and I'll go through this with the guys too. And the way I'll pay that is I'll give them, if I'm paying them 25 grand. I'll give them 10% of the gross amount held. In this case, it was 50 grand. I'll give them 10% up front, meaning within a week after they sign my documents. That gives me time to have my attorney double check the title work that was done to make sure that I'm not going to pay this guy money when they're not owed the money. So anyway, I'll give them that 5 grand. And then if it's a new attorney, new state, new area, new county, whatever, sometimes the attorneys won't do it on contingent. They won't do it for 10% plus court costs. They'll say, listen, I don't know you. You don't know me. I don't know if you're doing your homework right. I don't know what the heck you're doing. So I want $1 grand or $2 grand on a retainer. So if you're doing it on your own, go ahead and you need to have about 5 grand set aside for at least 2 deals, and those would be low deals. 5 grand for nice one big deal, let's say a $30,000 deal, in which case, let's say you paid the guys, 12, 15, whatever, you're going to total, but that's going to be at the end. At first you pay them 3, and then another 9 to 12 when you successfully get it out, but you need to have another grand or 2 for the attorney, so you need $5 grand. Okay? Now people are going to argue with me and say, oh, I can just use an assignment to me or a power of attorney. You know what? Here's what's happening. When the assignments of power of attorneys, first of all, a lot of counties aren't accepting them anymore. Secondly, you guys are trying to get an assignment to yourself or a power of attorney to yourself. What the attorneys are doing, or rather the counties are doing now, is they're saying, that's fine, you got a power of attorney or you got an assignment, that's fine, we're still going to cut it in the claimant's name and we'll send you the check and you figure out how to cash it. And you're not going to be able to cash the third-party check. If you have an attorney that can use their trust account to cash it out and honor the agreement, the structured buyout agreement you had, and they're getting it out in the claimant's name, it's very clean, completely legal, and you don't have any issues with that. That's why we tell you to hire an attorney. If you don't hire an attorney, and we've said this over and over again, and I know I'm going to make people mad that are very sensitive out there, and I'm not making fun of you for being sensitive, but good Lord, you're an idiot if you don't use an attorney in this business. You're an idiot. You're going to get burned. You're trying to save, you're trying to save a penny, and you're going to lose it all. Also, structured buyouts make me extremely competitive, so it's easier for me to put deals together. That's the first thing I wanted to cover, guys, is the costs involved. It's really not that much. If you're doing it on your own, obviously you're going to be doing mailings and calls. That depends completely on what you're doing. We give you example mailings and scripts, of course, that we've used that have been very effective, and that's in our course. But with the researcher, we give you right currently 8% of the gross amount, and all you're doing is researching debt and ownership. In January of 2020, we're going to launch a different system, and that's going to allow people to take it a step further, get in touch with the people as well. Just do a warm call. Hey, were you the owner of this property back in 2016, 1116 Barton Avenue? Was that you? Is this correct, Mr. Johnson? Okay. There's funds being held by the court. I have a third-party company that does structured buyouts on this and uses attorneys. They'll give you 10% up front. It's $32,000 being held. They'll also give you more money, of course, on the back end, and they'll pay for the attorney and never charge you a dime. Is that something you'd be willing to do? Have you already been contacted by a company you've signed with? Great. I'm going to pass it on. Name of the company is Greater Good Company. They'll be giving you a call. Boom. Instead of 8%, we're going to pay 16% for the warm lead. And that's, guys, and a lot of guys aren't going to believe me, that's 50% of my net in most cases. So I'm literally splitting the profits with you. You're researching debt and ownership and making a warm call. That's it. I'm hiring the mobile notary. I'm hiring the attorney. I'm putting the whole deal together, structuring it, getting everything done, and paying you a handsome commission on the back end. And we've been doing this a long time. So you get the benefit, of course, of our experience, our money behind us, and our knowledge, and of course our attorneys. All right, the second thing I want to cover is judgments, because if there was a judgment against the individual prior to that foreclosure, and it was recorded in the same county as where the house was foreclosed on, where the house was, okay? If it was recorded there, that also, think title work, guys, that also counts against the property, against the surplus funds, and that has a priority claim in front of the owner. If there's 30 grand there, there's a $10,000 judgment, and that's all there is against it, no mortgages. That $10,000 needs to be paid out to that judgment holder, and then the owner can take the rest. If it's $10,000 total, But let's talk about how judgments work. In most states, they last for 10 years, and then you have the option, the creditor has the option of renewing that judgment. Okay? So in reality, those states that have 10 years, most of them can actually go 20 years because the creditor can redo it. Now, does the creditor redo it at the end of the 10 years? In most cases, no. But there's also a grace period. So I want to warn you guys. Let's say, it's right now, I'm recording this November the 8th of 2019. Let's say you had a judgment, you're about to go make a claim, but you know that a judgment is against that person that's going to fall off. It'll be 10 years from when it was recorded, okay? From when it was recorded at the court. It'll be 10 years, November 30th. I'm going to wait till November 30th to make that claim because I'm going to go after all the money, because as of the 30th, that judgment isn't going to count and I can get the other 10 grand. Okay? That's simplistic. Sometimes states will give them a grace period, okay? Most of the times they're going to tell that creditor, hey, if you want to re-up this, you got to do it like a week in advance before the expiration date. But some of them allow them a grace period. Double check your statutes on judgments so you know. In that case, I wouldn't want to go make a claim, and if the court required me to notify the creditor if they actually made a claim also and they were still within their grace period and they re-up their judgment, you'd be screwed out of that 10. So you got to be careful with that. That's, you know, state statutes tell you about that and how to look at that. But they do expire, and that's important because that can make you a heck of a lot more money. Sometimes you'll want to put a case to the side if, for instance, the judgment is for a lot more money than the rest. I would still lock down the owner on the amount they're due and let them know there's a judgment. We're going to try to do something, negotiate with that or whatever. So it may be between, Mr. Johnson, we're going to try to go for the full amount. So I'm going to pay you based on that, at least my upfront amount. I'm going to pay you, but I might not be able to collect the full 30 grand. I'm going to give you 3 grand up front. Hey, listen, if the creditor shows up, the judgment person shows up, I may give you another grand or two, and that's it, because there's only 10,000 left. I might not even give you that. We'll figure it all out. But they'll agree to that, and they understand there's a judgment there. And of course, if you're waiting, you've got interest accruing on most judgments. There's usually a state statute on what that can be, and it's always, or in my experience, always been the maximum is what they put on there. Okay. And the other thing I want to do, and I've said this in other videos, I want to let you know that IRS tax liens function a little differently. IRS tax liens, even if, and now listen, if a judgment's put on against that individual after that foreclosure, it doesn't count against the surplus because it's after the foreclosure. Everything was kind of in stasis, okay? It was kind of frozen in time at the time of the foreclosure. In most states, that means when the deed was actually transferred to the new buyer. Okay, very important to know that. To differentiate that. So, having said that, the IRS lien functions a little differently. IRS lien could go against the individual a month after, a day after, whatever that foreclosure, but it could be against third quarter taxes from 2 years ago. So the IRS can play a little game. They're the only creditor that can do this and say, yes, we didn't get our judgment IRS lien recorded until after the foreclosure. However, it was against taxes from a year and a half prior, and they're allowed to predate that, even though their 10-year lien starts at the time it's recorded. They actually get the benefit of that 10 years plus the time prior to the point of when the money wasn't paid on taxes. Very important for you guys to understand that. Okay, IRS tax liens, you don't see a whole lot of those, but they're there. Now they do expire. The difference you're going to find with the IRS tax liens is that if you go to collect, some of the courts are going to require that you get a response from the IRS. Just so you know, you need to add on a month or two, because they're not going to, if it's past the lien period where the lien's no longer valid, they're still going to drag tail, and they're not going to get back to the court, and it may take you an extra month or two to get a response from the IRS. And you may need to get your claimant involved to help you with that. Have them call and yell and scream and bitch, excuse my French, at the IRS, so that they respond to the court and get it done. IRS offices are regional. It's fairly easy to look that up and figure it out, so it shouldn't be an issue. So what I've covered so far is judgment issues you need to be aware of, and also costs involved with setting it up if you're going to do it on your own. And again, January 1st, 2020, we're going to launch intro price, the 16% commission that we've got, where you, in addition to just researching debt and ownership, you just do a warm call. If you're comfortable with that, guys, it's going to make you a heck of a lot more money. And I'm telling you, that's extremely generous, okay? That's above most caps in most states for finders, meaning you could never make that if you're going to just do it as a straight finder. If you have any questions, pre-purchase questions, not after you bought, but pre-purchase questions, give us a call. I'm at 704-791-9398, Monday through Friday, 9 a.m. to 1 p.m. Thanks.